Donald Trump has once again gone after his former personal attorney, Michael Cohen, despite a court order not to discuss witnesses in his criminal hush money trial. The gag order was created to prevent Trump from talking about court figures, and the judge has already been considering if Trump broke the order within social media posts about the case. This latest interview is only adding fuel to the fire for Trump's legal team.
Well, Michael Cohen is a convicted liar, and he's got no credibility whatsoever. He was a lawyer, and you rely on your lawyers, but Michael Cohen was a convicted liar. He was a lawyer for many people, not just me.
The former president talking exclusively with Philadelphia's Action News, once again flagrantly disregarding a gag order that bars him from talking about witnesses.
It's all a scam. It's a big, giant scam. It's election interference at a level that really nobody's seen before.
Trump has repeatedly attacked Cohen, who was at the center of the alleged hush money scheme the trial focuses on. Prosecutors claim Trump falsified business documents while illegally covering up hush money payments made to hide previous affairs just before the 2016 election.
They have a person, a bookkeeper, that I didn't speak to. They have a bookkeeper write down on a ledger that a legal fee is a legal expense. What else are you going to call it? It is a legal expense.
When it comes to the court order on speaking out about witnesses, Judge Juan Merchan already began considering yesterday if Trump previously broke the order by making up to 10 social media posts about the case. He could face a $1,000 fine for each violation and possibly jail time.
The judge is highly conflicted. He should recuse himself immediately. There's never been a judge so conflicted as this guy.
On Tuesday, the first trial witness, former National Enquirer publisher David Pecker, testified that he used his supermarket tabloid to suppress stories that might have hurt Trump's 2016 presidential bid. Pecker saying he met with Trump and Cohen in 2015, and he said they asked, quote, "What can I do and what my magazine could do to help the campaign?"
I thought what David Pecker said was truly shocking. A media outlet, even if it's considered maybe a down market media outlet, was in cahoots with one political candidate. That is what happens in Russia. That is not what is supposed to happen here.
Pecker testified that he told Trump and Cohen, "What I would do is I would run or publish positive stories about Mr. Trump, and I would publish negative stories about his opponents. I said I would be your eyes and ears." But now to the question we've all been wanting Trump to be asked.
Are you prepared to take the stand if it comes down to it?
Oh, sure, I'd very willingly take the stand.
Trump's criminal hush money trial will resume in New York tomorrow. Also happening Thursday, the U.S. Supreme Court will hold arguments on Donald Trump's claim that he enjoys sweeping immunity from criminal prosecution for actions he took as president.
But the fact that they took the case, to my mind, sends a signal that they are at least considering seriously this argument, and so there is at least a non-zero chance that some number of justices might sign on to this, I think, quite extraordinary argument that Trump is making.
It's Trump's highest appeal that has for months paused the federal case accusing him of attempting to undo his defeat in the 2020 election.
But I do think that it's not really an overstatement to suggest that kind of stakes for constitutional democracy are extraordinarily high.
Joining us now from Harvard University is Professor Ronald Sullivan. Professor, I want to first ask you about this gag order for Trump. We heard him talking once again about Michael Cohen in an interview last night. He's facing the possibility of fines, but could Trump be jailed for this?
He could be jailed theoretically. I doubt that he will be. It's almost assured that he'll be fined. He has repeatedly violated the gag order. And in fact, he violated it like on the way to the gag order hearing. I mean, he is just sort of blatantly disregarding the gag order. And I think former President Trump realizes that the trial judge is in quite a bind with this because money is not going to hurt him. What is it? 11 violations, $11,000. That's like, $5 to me. And jail would cause such a separation of powers problem that it probably, it would turn him into a martyr. So so I think it's a really tough position for the trial judge, but it really undermines the integrity of the judicial process, this sort of conduct.
So would someone who is less privileged than Trump already be facing penalties as severe as imprisonment? So I guess what I'm asking is, despite Trump's claims, is the judge being lenient here?
Oh, my goodness. I think Judge Merchan is being extraordinarily lenient toward the president. Anybody else would have been, under the jail, as the old expression goes. I mean, they would really be in jail. Court does have the power to put people in jail for contempt and fine them severely for contempt. So in the normal circumstance, and I realize nothing is normal about this case, but in the normal circumstance, a person would have been in jail, because you cannot just sort of flout the authority of the court like that and it go unpunished. It just doesn't happen.
And turning to David Pecker's testimony yesterday, would you say he's now the smoking gun for the prosecution with what we've heard?
Smoking gun might be a little strong, but it is one of the pieces of the puzzle that puts this entire picture into focus. Here might be an interesting way to think about it. An old U.S. evidence professor called Wigmore, probably one of the most famous evidence professor ever, had this expression in evidence, and that is, a brick is not a wall. So think of each piece of evidence as a brick, and brick by brick by brick by brick, you build this wall. So Pecker is adding 3 or 4 or 5 bricks. Then Cohen will come in and say, I spoke with President Trump directly, and he directed me to do this. 9, 10, 11, 12 bricks. Other people will come in, and the prosecution hopes that all of those bricks will morph into this wall, and from their perspective to say guilty. Now, the defense will want to take a jackhammer and just tear that wall up, and that's what cross-examination is for. So we haven't seen cross-examination, and that the purpose of that is to undermine these bricks that have been built.
Now, I love the analogy. It's a perfect one for Trump, because we all know he loves walls. Just perfect.
This doesn't work out. You've got a career in stand-up.
Thank you, Professor Sullivan. Now, I found your article about opening statements fascinating. How crucial are they when it comes to the jury's decision-making?
Extraordinarily crucial. And they're crucial because this is the point in time where the advocate gets to frame the evidence that the jury will hear. I cited some research that says up to 75% of jurors make up their mind after opening statement, and they maintain that same position throughout the entirety of the process. So that, and some people dispute some of those numbers, but the point is, it's significant, and trial lawyers would be wise to recognize that a good number of jurors make up their mind early. So openings, very important.
So just quickly, in this case, did we have a clear winner?
I don't think so. I think both sides did a great job.
All right, Professor Sullivan, thank you for joining us tonight.
Thank you. Take care.